And we will go ahead and begin. We're going to start with the initial hearing on the disciplinary matters, or the initial hearing in the matter of the charges filed by Roxane B. Stillman against Chief Koval and Tom Helgren.
Would you like us to move up?
Yes, please do. Okay, and if Roxane Stillman is here, please do come on up as well. Again, welcome. And this is the initial hearing in the matter of the complaint of Roxane Stillman against Police Chief Michael Koval and Detective Tom Helgren, dated August 17, 2016, and served by stipulation through the respondent's attorney. I'm Commissioner Wes Sparkman, President of the Police and Fire Commission, and at the table with me are Commissioners Yap, Campisher, Hamden, and Trammell, and PFC Counsel Scott Harris. We conduct this initial hearing pursuant to Rule 6.08. Would you state the appearances, please? So first you can state your name.
Roxane Victoria Stillman.
Okay. All right.
I'm Andrew D. Schauer, Staff Attorney for the Wisconsin Professional Police Association, here representing Detective Tom Helgren.
I'm Lester Pines, calling Weston Pines and Bach LLP. I represent Chief Koval.
And Detective Tom Helgren appears in person.
Okay. Does either respondent wish to file an optional written answer?
Yes, we do. We'd love to set a time in the next couple of weeks to get that to you. We're also interested in filing a motion to dismiss.
You'll file a written motion?
Yes. Yeah.
And you're saying within 2 weeks or so?
Yeah, if that pleases the commission, we're happy to do that within 2 weeks. We'd ask, though, that the commission then set the matter for a continued initial hearing in order to hear arguments, consider, and rule on that motion to dismiss.
I'll join in that so that the schedule stays the same for both.
All right, does any party anticipate filing any written motions prior to the evidentiary hearing itself?
I jumped that question.
Yes,
yes, it's previously discussed.
Okay. All right. All right, and when will the complainant be able to disclose her intended witnesses and exhibits?
Well, there's going to be several, but I was told not to bring any witnesses tonight.
That's right.
But it's going to be Schwen.
The question is when. You can do it at any time, in other words.
Oh, okay. So I don't have to tell you the witness. Okay. So.
But you're ready to do that at any time. You're ready to disclose your witnesses whenever.
Yeah, I can, but not tonight. Then I'll just wait. Thank you.
So, commission will set a date certain by which she should do that in writing. And
well, can I
Go ahead.
let me jump in on
apologize.
Can I make a suggestion, Scott? Perhaps
Please do.
It would be helpful to Ms. Stillman that you could give a brief explanation of what it is we're actually doing in terms of the scheduling.
Yes, that's what I was about to. Ms. Stillman, Attorney Schauer has asked the commission to give him a couple of weeks to file a written answer and a motion to dismiss, and then to schedule argument about that motion to dismiss. if the commission decides to do that, as he's asking, then that puts off the question about when is the hearing, when is the trial going to take place. Those are all pre-trial proceedings that would take place before the trial actually occurred. You follow what I'm saying? So in that sense, we don't really need to look at the trial preparation stuff now. We would just need to look at scheduling these pre-trial matters, the motion to dismiss and that kind of thing. And then we'll pick these pieces up about setting the hearing date and witnesses and exhibits until after that issue is resolved. Now, is that a fair explanation, Mr. Schauer? And do you follow what I'm saying, Ms. Stillman?
Yeah, I do. What I was planning on telling tonight, if we can't go forward with it, and they're asking for dismissal, I don't want to dismiss, so I will then talk to my witnesses, and we will hire an attorney if need be. I talked to some of them today. We will hire an attorney and come forward with it then. All I'm asking for is a job to be done. I didn't want to be this harsh. I just wanted the job done.
Well, President Sparkman, then I'd suggest if commissioners wish, the thing to do might be to just go ahead with scheduling the motion to dismiss and pick the case up from there.
Okay, sounds good. What do the commissioners think about that?
So the intent is that we'll hear the motions to dismiss, and then if the case survives, then we'll do further scheduling, so we'll have another initial pre-hearing.
Yes.
Okay.
That's what I'm hearing too.
I think that's a reasonable approach.
All right. Okay.
So you can file the motion and answer in 2 weeks?
Easy.
So why don't you do that, and the commission will take up the scheduling of that after that point. We'll give Ms. Stillman some time to respond to that, and that'll get us towards the next PSC meeting by the time that all happens. But let's just schedule the filing of the motion and answer for as far as what we scheduled tonight is concerned.
All right.
Is that all right?
And if the complainant wants to respond in writing, should she be told to do that upon receipt and before the next, before when the matter would be scheduled? Just to allow her the opportunity. I want to be as fair to the complainant as possible.
Good. How about if we say, when you receive the written papers that are going to be filed within a couple of weeks, then you have 14 days from then to, if you choose,
I will.
to respond in writing. Well, you'll be given a chance to respond orally if you wish, but a response in writing would be fine, and you'll have 2 weeks to do that. Okay?
That'll give me a chance to talk to the lawyer, because I definitely do not want it dismissed. No way.
Okay.
No way.
So 2 weeks from today's date for us would be September 26th, or not, correct?
No, that's all I got.
All right. All right, and
And you'd be looking at October 10th. 2 weeks after that would be October 10th. You're getting 14 days.
Yeah.
So the 26th.
That is our regular meeting date, so should we plan on doing the motion at our regular meeting on October 10th?
My suggestion about that is to leave that undecided right now.
And I would prefer that we have an opportunity to review the motions before we actually have a meeting. So.
Okay. All right. Yep, that makes sense. All right. All right, now we're going to move on to time, kind of scheduling here. And how much time?
Well, you could just pass over that.
Yeah, we're going to, because it's unknown.
Yeah.
I think.
We'll come back to that if the case survives.
Okay. All right, is there anything further from any party?
no, thank you, sir.
Okay, our attorney will issue a scheduling order reflecting this case calendar. This matter is in recess until we reconvene for evidentiary hearing.
Well, as will be scheduled.
That's good.
For a continued
Continued initial hearing or other proceedings as may be scheduled on the motion.
Thank you.
Thank you.
Thank you.
Okay?
All right.